Good morning, everyone, and welcome to our Hull and Hull Breakfast Series. I'm Susanna Popovic-Montag and very pleased to be here to chair our breakfast this morning. I would like to welcome everyone who's here in person with us here in Toronto, together with all those who are watching on the web and listening on the phone. Thank you for joining us. We have what we hope to be a very interesting discussion for you today, and in keeping with the way that we usually run these, we are hoping to wrap everything up by 9:30, at which time we open it up for questions that anyone may have. There are microphones for those here in Toronto with us that we ask that you step up to and place your questions there. During the course of our presentations, we're also going to continue to try to use our fancy technology here, and we'll have questions during the course of the presentations. We'll ask you to participate, and you do completely anonymously, so there are no wrong answers, but we do hope that you'll enjoy that part of our program. We have our guests of honor here this morning. We've got firstly Jonathan Cappy, who's going to be presenting. We have our our counsel now, who's recently joined us to our firm, David Friedman. We're very pleased to have him join and present so quickly upon his arrival here. And we've got, of course, Ian Hull, who's going to be speaking. We've got a number of members of our firm here today, and I just ask them to acknowledge themselves to everyone who's here. We have David Smith, Paul Trudell, Crystal O'Donnell, Stuart Clark, Noah Weisberg, Holly LaValliant, Doreen So, Andrea Bunchik, Joshua Eisen, Moira Visiu, and we are also joined by Heather Fritchkowski, who you met at the front when she was welcoming you here. We have Christine Mercer, Heather McGuinness, Lisa de Grosselier, Jocelyn Martin, Reese Newman, Nick Esterbauer, Michelle Kotzer, and the two ladies in the front, Diane Labau and Sarah Koslicki. So, with no further ado, we're going to ask Jonathan if he could please start with his presentation about form over substance, allocating dividends between income and capital beneficiaries.
Thank you. I wanted to talk about dividends, and dividends in particular where a trust is the shareholder of a company and money or property is passed from a corporation, and in particular an active corporation, to its shareholders. And when that happens, there are a lot of things that need to be considered. There are a lot of complex issues that a trustee needs to balance in determining how to treat that money or property in the hands of the trust. Where there is a single beneficiary, there are less problems that can arise, but in particular where there is a split between the different classes of beneficiaries, between income beneficiaries and capital beneficiaries, there can be very complex issues that need to be determined in order to ascertain whether or not the income beneficiaries should be entitled to that property or whether or not the capital beneficiary should receive it. A typical example, just for discussion purposes, is a spousal trust where the spouse is entitled to the net income from the trust property. Oftentimes there's a right of encroachment, and then there's a gift over to the children of the capital assets of the estate. Now clearly in those circumstances there is a conflict of interest as between the different classes of beneficiaries, and a trustee is going to have to deal with those issues when determining how to allocate dividends that are passed on where the trust is the shareholder of a company. When dealing with the trustee's discretion in allocating these types of assets, the first thing that we need to consider is the even hand rule. Going to first principles, a trustee has a fiduciary obligation to all beneficiaries of the trust, and it has a duty of impartiality. A trustee cannot give any advantage to one class of beneficiaries over another. And at all times when exercising his discretion, he simply cannot favor one class of beneficiary over the other. This even hand rule applies both on the income side of the trust as well as the expense side of the trust. As it relates to generating income for the trust, a trustee cannot unfairly balance a portfolio to provide for income at the expense of capital growth, and certainly he cannot ensure significant capital growth at the expense of income being generated from those assets to the detriment of the life tenant. So it is a balancing act that a trustee has to maintain, and there are certainly examples in the case law of trustees being removed where that balance was not maintained. Even on the right of encroachment, trustees can be criticized for not encroaching where it's appropriate and encroaching too much where not appropriate. And again, this is all rooted in discretion by the trustees. So let's go to dividends in particular, and let's check out our first slide. Sure, expenses incurred by a trust must be allocated equally between income and capital beneficiaries.
So is that true or false? Did you want to continue, or we can close?
Sure, we can, yeah, let's close the polling. And 70% said false, and that's correct. So just as we have trustees have an obligation on the income side to find a fair balance as between the income beneficiaries and the capital beneficiaries, similarly on the expense side of things, it is not an equal allocation as between them, but it's an allocation on the basis of the expense that's being incurred. So where expenses are incurred for the benefit of the life tenant, for example, if they are living in a house that's owned by the trust, expenses related to the maintenance of that house or the insurance, that would be allocated to income and reduce income, whereas major improvements such as a major renovation to the house that would benefit the capital beneficiaries would be allocated to capital. So let's go to the next slide, and we'll start getting into the dividends in particular. So the question is, which of the following forms might a dividend take? And there's cash out of undistributed income, cash out of stock or property, a distribution of stock or property, a cash payment out of undistributed capital, or all of the above. So let's close this. Let's close the poll. And 95% said all of the above, and that's correct. The reason that the issue of allocating dividends as between income capital beneficiaries is that dividends can take many different forms, and it can come from many different pools of money in the hands of the corporation. And that's what makes the analysis so complex. Dividends can take the form of cash payments, either out of undistributed profits, out of surplus, out of capital. It can take the form of a distribution of stock, being the stock of the company itself, preferred shares or other shares of the company. And it can also take the form of a distribution of other property, for example, distributing stocks of another company. And so all of those qualify as dividends, and it's something that the trustee has to wrestle with in terms of allocating as between different classes of beneficiaries. So let's go to the next slide. What is the overriding determining factor as to whether a dividend can be classified as income or capital? Is it the legislation, the terms of the trust deed, the directors of the corporation, or some other factor? So let's close the poll. And 61% said the terms of the trustees, and that's correct. Because we're talking about discretion. In terms of allocating as between the different classes of beneficiaries, we're dealing with the trustee's discretion to allocate. So where the trust deed itself, or the terms of the will that create the trust, set out where this money is to be allocated, that is the overriding principle that governs the conduct of the trustee. Let's do one more slide before we get into the case law. In the absence of a will or trust instrument stating otherwise, the form rule will determine whether a capital dividend is considered to be income. Right? Let's shut it down. And the answer is true, and that's correct. So I certainly can't touch upon all of the cases that deal with dividends in the hands of a trust, but I want to lead you through some of the leading cases that deal with how to view dividends once they are passed along to the shareholders who happen to be trustees. Let's start with the Privy Council decision, 1930, of Hill and Permanent Trustee Company of New South Wales. While it's certainly not the first case to deal with this issue, and in fact you can go back as early as 1887 in a decision of Booch and Sproul out of the House of Lords, but the Privy Council sets out some good general rules to guide trustees in terms of how to allocate these dividends, and so we'll begin our analysis there. In the Hill case, this was a corporation that sold substantially all of its assets and then subsequently declared a dividend in cash to its shareholders. Importantly, that the court considered that this was, for all intents and purposes, an active company. This company was not in the midst of a winding up, and in fact, a resolution had been brought to the board of directors of this company for the voluntary liquidation of this company, and that resolution had been defeated. So for all intents and purposes, for this analysis, it is an active company, and that's a very important factor to consider. So notwithstanding that the pool of money came from the sale of the assets, of the capital assets of the company, the Privy Council held that this should be considered income in the hands of the trust. The court said that the form of the dividend, not the substance of the dividend, dictates how this is treated in the hands of the trust. And this was notwithstanding that even the company itself in the resolution that declared the dividend acknowledged that this was coming out of the capital of the company. Now, the court acknowledged that the form rule itself could be inherently unfair, that there are certainly circumstances where using the form rule of form over substance to determine how to allocate these dividends could lead to injustice to the income beneficiary and certainly could lead to injustice to the capital beneficiary. But the court was guided by a number of core business and legal principles that it used to come to the determination that this should be the analysis going forward. Firstly, the court considered that the company itself does not care what happens to this dividend once it leaves the company. It does not care one way or the other whether this is treated as income or capital once it gets to the trust. So that is not one of the guiding principles when the company chooses the form to declare this dividend. Number two, the Privy Council held that a corporation that is not in liquidation cannot return capital to its shareholders other than by an authorized reduction of capital. What that means is that the only way for a company to return capital to its shareholder through cash is to redeem shares already held by the shareholders. And that therefore, when a company distributes cash to its shareholders, when it's an active company, that must be a distribution of profit. And so the court held that prima facie, any distribution of money, and we're talking money right now, to the shareholders of a company that happens to be a trust should be considered income. And of course, as we spoke before, the court acknowledged that, listen, if a settler or if a testator wants to change this direction, it can certainly provide for in the context of the trust deed itself. So this is only where the trust deed does not provide for the allocation of these dividends. And then after finding that the monies would be considered income, the court found that any distribution of capital stock of the company would be considered capital in the hands of the trust. So from there we get this general form rule which provides that any distribution of money that's not a redemption from an active company is considered income, and any distribution of capital stock of the company will be considered capital in the hands of the trust and allocated to the capital beneficiaries. In 1956, the Supreme Court of Canada considered the decision of Hill in the Rewaters decision, and the court accepted that analysis. The facts before the Supreme Court of Canada were actually the corollary and the exact opposite of the case before the Privy Council. In Waters, the company had accumulated a significant amount of profits that it had distributed to its shareholders. Now, the court acknowledged that it could have done a dividend by way of cash, but because of the way the Income Tax Act was structured at that particular time, the corporation chose to capitalize that profit and distribute that in the form of shares, redeemable preference shares, to its shareholders. So really what it did is there was a pool of $240,000 of profit that the company had, and what the corporation did is it converted that profit into capital, and instead of paying cash to the company, they created $240,000 worth of redeemable preference shares, which it distributed in the form of a dividend to the shareholders. And then thereafter, the company slowly started redeeming those shares to get the cash into the hands of the shareholders. And because it was distributed in the form of capital of the company, the Supreme Court of Canada held that it should be considered capital in the hands of the trust, notwithstanding that it was really profit of the company that was being passed along to the shareholders. And the Supreme Court of Canada made clear, they said here form is substance. And as soon as that company converted that profit into capital of the company, the shareholders of that company, including the trust, are bound by that decision, and they accept it as capital, and it should be treated as capital in the hands of the trust. Now, interestingly enough, in Obiter, the court considered a situation where a shareholder was given the option of choosing a dividend by way of cash or choosing a dividend by way of capital stock of the company. And in the case, although it's Obiter, the court comments that where the shareholder is given the option, it will be considered income in the hands of the trust. The reason is that where you are given the option of picking one or the other, if you choose to accept it by way of a dividend stock, it's really a two-step process. Number one is the creation of a credit from the company to the shareholder, and number two is the satisfaction of that credit by the issuing of stock to the shareholder. So once you have the choice, it will be considered income, and from that perspective, a trustee can't pick and choose whether it's going to be treated as income or capital. In the Smith Estate and Smith Estate case, which was a 2000 decision out of the British Columbia Supreme Court, we get into a situation where it was a wind-up. So there, a cash dividend was declared upon the wind-up of a company following the sale of substantially all of the assets of the company. The company immediately thereafter was dissolved. So in the context of that analysis, the court held that because, number one, it was a winding up of the corporation, that it had to be considered capital. Notwithstanding, and irrespective of the pool of money that it came from, once you're in a winding up scenario, it's got to be considered capital in the hands of the trust. And that goes back to a Armitage case, a case from 1897, that says that once you're in a wind-up scenario, the company is no longer authorized to declare a dividend. And therefore, any monies that are passed on to the shareholder in the context of that winding up must be considered a return of capital. So the last issue, the last case I want to touch upon is a decision of Re Welsh, a 1980 decision out of the Ontario High Court. Now, Re Welsh was also a situation where the company sold substantially all of its assets and passed along the funds to the shareholder by way of a cash dividend. But this one was a little bit different, and the court used a bit of a different analysis. In this particular case, the shares comprised the sole assets of the trust. That the spouse in this particular case, who was the life tenant, had been receiving income over the course of this trust, and that if this cash dividend under the form rule was considered income, the capital beneficiaries would have received nothing. And so in this particular case, the court distinguished itself from the case of Re Waters and Re Hardy, which is a similar case from Waters, by saying that Re Waters dealt with distributing surplus income, and in this case of Re Welsh, we were distributing the capital from the sale of the assets of the company. And the court, in determining that it should be treated as capital in the hands of the trust, expanded, I think, the scope of the trust document itself in the context of determining how this money should be allocated. And the court said that the overriding consideration must be the intention of the testator as expressed by the words of his will and in the circumstances in which that will was executed. So the court looked not only at the words of the will, but also at the surrounding circumstances. Because in this particular case, at the time that the will was drafted and executed, the Income Tax Act, just as in Waters, was likely to have led to the company paying out that capital in the form of a capital dividend by distributing redeemable preference shares. But because the Income Tax Act had changed since the will was prepared, the dividend was paid out by way of cash. And so the court held that there was no doubt in the court's mind that the testator intended to have this money go to the capital beneficiaries, and in all the circumstances, given that that was the intention, it was allocated to capital of the trust. So let's go to our next slide. If trustees are also the directors of the corporation, they will be governed by the even hand rule, the form rule, both, or none. And let's close it. And C. The correct answer is that where a trustee is also the controlling mind of a corporation, it is actually the even hand rule that will govern his conduct. The courts will not allow a trustee wearing a different hat as a director to control whether or not this money gets allocated to income or capital, because the director can certainly choose the form, and so is not governed by form rule, but is governed by the even hand rule. Yes.
That's great. Thank you very much, Jonathan. And good job, audience. Got most of those questions right. I'm very pleased to now turn the podium over to Ian and to David, who are going to solve all the world's problems as they talk about the reform of trust law.
You go first. All right, I'm going to start. First of all, I just want to welcome David formally to the firm as well, and take this opportunity just to give everyone a little bit of background on his experience. David carries on a professorial role at Queen's in teaching wills and estates, and also a boisterous and busy litigation and estates practice in the Eastern Ontario, based substantially out of Kingston, but will be more than available to be in Toronto with from time to time with our firm and on an active basis as well. David's background is really well suited for many things, but especially with this discussion. He's got the sort of academic side and the practical side locked down. No one really, I think, in Canada has touched these two corners of the estates practice like David has, in the sense that he's able to really add some academic prowess behind these cases and his analysis. A little bit of background on David as well. Although he doesn't want me to say all this stuff, I do want to let everyone know that he's based on his social media presence alone. A lot of people know him. He's through the Canadian Estates and Trust Litigation Group and LinkedIn that he started and maintains and keeps the discussion lively in the past year through a lot of good people in that group. But he's also obviously got the academic training at Oxford for his master's and Cambridge for his PhD. So he spent some time in school. All right, so David and I thought what would be interesting to do is look at the Uniform Trustee Act and take that act, analyze it a little bit, and look at some of the practical implications of how it may or may not impact on our day-to-day practice. Certainly in the area of trusts alone, the Act gives us an opportunity to rethink some of the work that we're doing on a day-to-day basis in trust drafting and trust litigation. The first question I will ask Susanna to call up, get my technology working here, is, not working, sorry. First of all, what is the Uniform Trustee Act? Is it current legislation governing trusts and trusteeship in Canada? Is the legislation coming into force later in 2014? Is it a proposal for trust law reform in Canada? Or D, are you unsure? So take a moment and vote on that one, because it's a good starting point to the discussion. All right, so why don't we close up our voting and see what people say. I can't actually see it from here, but if the answer is C, a proposal for trust law reform in Canada. Fantastic. So, David, let's start with just a general discussion of what is it, why did this come about, and what kind of proposal is this, and what flaky academics are doing to us.
Okay, well, good morning, everyone. First of all, thank you, Ian, for the wonderful introduction. It was worth the few dollars I had to pay for it. Thank you. I think that Jonathan's paper, first of all, was a great paper and is a great start to discussing this topic. So, and I hope you don't mind if I take maybe 3 minutes to give you some background here. We have something called the Trustee Act, and the Trustee Act is actually a number of statutes that came together in the 19th century, and they basically set out default considerations that drafters could use in drafting a trust. So it's the kind of stuff that we assume that people want unless you draft around it, right? So it's not a mandatory code. The only problem is that a lot of it was drafted at a time where considerations have changed. So part of the Trustee Act comes from early 19th century Trustee Acts, where married women couldn't own property in their own name, where family trusts were the only kind of trusts, and the primary asset in the trust was land. And so a lot of it is out of date. So what the courts have done over the last 150 years is they've filled in the blanks. And so how do you allocate dividends? Dividends is between capital and income. You haven't provided something in the trust instrument, therefore the courts fill in. And they fill in, over time. Even a 1930 judgment deals with a range of financial products in a commercial context, which is much simpler than our own. So I remember I used to have a math textbook that had like about a 3/4 page of math equations, and the first line was, from the above equation we can clearly see, and a conclusion. And I could never see the conclusion. And that's kind of the state of the law now. There was a great, Jonathan explained to us all the technical rules about allocating as between form and not, whether a dividend is not in the form of a dividend, how a trustee should exercise his or her fiduciary obligations and being fair to different classes of beneficiaries. Very, very technical. This Uniform Trustee Act is an attempt to try to create a modern act, an act that reflects modern presumptions, that uses modern language, that adopts default positions that may be at variance with the default positions that were appropriate, 100 years ago. So this was undertaken in 2009 by the Uniform Law Conference of Canada, which is sort of a quasi-governmental organization, mainly public law officers. It was based on research that was done by the BC Law Institute, which also incorporated or which used research that informed the British Parliament when they revised their Trustee Act in 2000 in major ways. And so it really is an attempt to comprehensively, to the extent that it's possible to do so, by a bunch of private individuals, private individuals as consultants and public law officers, to make suggestions as to what a comprehensive statute would be. It was released a couple of years ago. It's for consideration by the provincial legislators when they get off controlling dangerous dogs and determining what should happen in Ukraine, which is, I think, what was the last item on the agenda of the provincial legislature in Ontario before they broke up. Then they might turn their mind to trust law. It's possible that this will become law. At this point, I think what it does do is it represents practices that have either been conventional or are conventional by now, or reforms to problems that commonly arise, and a set of reforms with commentary for our consideration. And I just would like to make the point that notwithstanding the fact that it's not law yet, it still represents a lot of good knowledge, so that, you know, drafters can choose to exclude a trust settlement from the operation of the Trustee Act if they so choose, and, you know, there are risks of doing so. This new draft uniform statute presents another series of provisions that, though they're not law, may well be an appropriate basis upon which to draft clauses for trust agreements now, trust settlements now. How's that?
Awesome.
Or we can talk about the HABs.
Yeah, this is the only list between David and I are hockey commitments. All right, so David, let's talk first of all about what would you describe as major reform that comes out of the Act, and there's various parts of it, but why don't we talk through some of those?
Okay, there's a lot of areas that are major reforms. The first one that I would suggest is worthy of having a look at is how we deal with private purpose trusts. So right now, as a fundamental proposition, you can say that the law of trust recognizes charitable trusts, and it recognizes trusts for individuals, you know, private people, corporations, whatever. But it doesn't recognize and it doesn't allow a trust for a purpose rather than a person unless that purpose is charitable. And the difficulty is that, you know, that rule, the beneficiary principle rule that prevents private purpose trusts, was determined at a time before really there was corporations, and certainly at a time before there was not-for-profit corporations. So one of the reforms in this uniform statute is to get away with that, get rid of that distinction, to allow private purpose trusts on a range of, you know, allowable criteria, and that's still to be worked out a little bit within the statute. And I think that's important because what it's clearly pointing to is a convergence of not-for-profit corporate law, charities law, and private purpose, new private purpose trusts to allow for comprehensive complementary coverage within those areas, where those three areas really are more alike than they are distinct. So this is a, you know, as a matter of fundamental trust law, a huge development. And I think it's important because it may well lead us to deal with trusts, charitable trusts, in a different way. There are some jurisdictions that have charities commissions that remove the decision of whether a purpose is sufficiently important from a court to an administrative tribunal or an administrative agency, and that's the way what we might be heading. And if that's the case, as far as I'm concerned, that's a very good thing. You know, the Charities Commission in the United Kingdom works very, very well, but we're a federal country, and so that may not, you know, be on the books for us. But certainly the abolition of the rule against private purpose trusts is a major reform if it's adopted.
And it's interesting in the context of what the Ontario government has tried to do and has still not closed the door loop on, as typical for their legislation, with the new legislation on not-for-profit corporations, where they've revolutionized in some respects the governance, the statutory governance, but they haven't, of course, promulgated it, and it's sort of out there. And so all of the people who are dealing with not-for-profit organizations are in this limbo. This is another great nudge to legislatures to say, look, there's a way to simplify this, and there's a process that's working around the world that we could incorporate. But I agree with you. It highlights the important distinction that exists now, and it's a nice reminder that we, in our practice, certainly we run into this debate with the PGT's office from time to time as to whether or not a trust has got a charitable purpose to it, and if it doesn't, what do we do with that trust? Do we cypre it? How do we manage that issue? So that is an important reform. All right. The next one I think we want to talk about is one that only professors ever really care about, but it's nice that they're going to abolish it. And that's the rule against perpetuities. So, David, will you lose your job if we get rid of the rule of perpetuities?
Now I get to ask my own question. Does anybody understand the rule against perpetuities? Anybody care to explain it, on the web or in person? Nobody understands the rule against perpetuities. My favorite case is a case from the United States where a lawyer got sued for violating the rule against the perpetuities and drafting a will. He wasn't found liable in negligence because the court said nobody understands the rule against perpetuities. The proposal in this draft statute is to abolish it and to abolish the rule against accumulations of income, and that's probably correct. It doesn't really help anymore. If we wanted to retain it, we could set a number, 100 years, something like that. But it would be a wonderful thing. I don't understand the rule against perpetuities. I've never tested a student on the rule against perpetuities. It's a hole for you to fall into. It's easy to avoid. There are problems with perpetual trusts. I don't know that anyone actually, as a private person anymore, wants a perpetual trust. The tax, laws have changed since the 17th century. It's just not in anybody's interest. This is just a simplification of the law. If they do anything, get rid of the rule against perpetuities. It saves me. It's the one lecture I give every year where I say to the students, there are no questions allowed.
Oh, that's good. Well, it's good to see that you're going to be able to keep your academic cash flow going. All right, so let's move on to what I think David and I were chatting about before, and I think this is a great illustration, what they're trying to do, because it illustrates what is happening and what they think they can do to fix it. Certainly from a litigation and contentious standpoint, removal of trustees is, in my experience, certainly the most contentious area of our practice, because when you get into it, you really have to call the trustee out on everything, and it gets very ugly and it gets very personal. Because the courts are reluctant generally to remove a trustee. If you bring an application to remove trustees, there's a heavy bias against you. So to achieve that, get over that hurdle, you do have to give some really detailed and profound illustrations of why that trustee has to get out, and sometimes it gets a bit personal. But the Uniform Trustee Act here that we're talking about has touched on that, and David, why don't we talk a little bit about your thoughts on the existing and what the Act tries to do.
Okay, well, I think Ian's explained what the existing law really is. I mean, there's a jurisdiction under the existing Trustee Act to remove trustees, and that's normally for cause. The court has an inherent jurisdiction to remove trustees in a wider variety of circumstances, and it requires going to court, so it's costly. The new draft legislation tries to draw a distinction between removal for unfitness and removal for cause, and to delegate the unfitness decision to the majority of the trustees. So, now you could draft a trust settlement to allow for removal of a trustee by other trustees, and it raises all kinds of problems in terms of fiduciary obligations. But this new draft statute allows for that. It allows for criteria set out in the statute to be used by a majority of trustees to remove one of their number on notice, and then that removed trustee may bring an application for reinstatement before the court. And perhaps, Ian, you could comment on the business potential of this particular provision, because it seems like it's one oriented to make work for lawyers, which is not necessarily a bad thing.
I would agree, because we're going to be into applications to reinstate. And so then I get to bring an application to show how good I am, and in fact how beautiful of a trustee I should be reinstated on. And so the whole thing does get a little bit circular, but I think at least they're talking, I mean, Section 37 of the Trustee Act currently it brings out, as I say, ugly litigation, but it also brings a lot of uncertainty. What is the threshold of a behavior that meets the kicking you out of the box status? And this at least gives us some guidance, and I think it will be hard to economically reinstate. It's going to be, why a trustee would want to go to the trouble of reinstating from a practical standpoint is hard to envision in some cases, but in some cases, of course, certainly in the family law context, if you get kicked out as a trustee, one of the spouses may want to fight very hard to get back in. So there might be non-financial reasons to do it. So I think it's an interesting illustration point. Another area that we are troubled with in the current situation when and the Act touches on a little bit is the duty to account and information provision of information by fiduciaries. And I think, David, you would describe this as a partial major reform.
Yeah, so there's a common law duty to account, and we've got lots of rules as to when trustees should account and when a beneficiary can cause a passing or someone else can cause a passing of accounts. And so the statute doesn't really touch that very much, other than to say that there should be regular accounting at various fiscal periods that are relevant, and you could draft around that quite easily, I suppose, and it just really reflects common practice in my view. But one major aspect of the law that is suggested for reform is provision of information to beneficiaries. And the law in Canada is still somewhat unclear. You might recall the decision of the Privy Council in Schmidt and Rosewood Estate a number of years ago that changed the law from a series of technical rules as to whether the beneficiary had a right to see certain documents to providing the court with discretion to order disclosure of the information to the beneficiary, and for perhaps the court to inspect the information before it does so, sort of similar to cases involving sensitive commercial information or even criminal proceedings. And so the uniform statute seems to legislate Schmidt and Rosewood Estate, that's which expands the rights to obtain relevant information on behalf of the beneficiary, and more clearly sets out that the court can exercise its discretion in balancing the interests in the trustee protecting themselves against just a fishing expedition and other beneficiaries being protected against unnecessary costs, but a beneficiary that suspects that something's wrong can actually get access to the information they need to consider whether a removal application or some kind of other remedy would be appropriate in the circumstances. So to that extent, I think that that's a very good reform, and along with abolition of the perpetuities period, I think that this is a fairly safe one to adopt, even immediately, if the legislators would be willing to do so. It makes sense and it works well elsewhere, and it should be adopted, in my view, in the common law provinces in Canada.
We get into a lot of contentious debates on the extent of information exchange, and the easy illustration is, of course, when you've got a corporation in the trust, and your fiduciary accounts are showing all the entries of the ins from the corporation, but you're not seeing the sub-level as to why is a dividend coming up and what basis is that being funded and how it's being funded, as Jonathan discussed, how it's being characterized as income or capital. And you will find lots of contentious issues that arise over, am I allowed to get right into that corporation? If it's partially owned by the trust, if you only have a certain interest in it, then it restricts your access. If it's wholly owned by the trust, am I allowed to get right down to the GL of the corporation? What am I entitled to get to? And I think from a practical standpoint, this provision really just demonstrates what I think is probably the way to go, and that is, if you're in a fiduciary situation, give, especially if you're not restricted. There just doesn't seem to be any sense in getting into a huge debate over access to the corporate level, but you get into these fights all the time, and as in a fiduciary role, I always say to my clients, not always, but good advice is just, look, just kill them with kindness, and if you give them too much information, it'll maybe bog them down a bit. All right, so David, the issues of delegation, the current status of a trustee being able to delegate is one that we your roles and day-to-day activity is one that we constantly run into, whether or not a trustee has gone beyond what he or she should have delegated to another. So let's talk a little bit about some of that tension that exists now, and then obviously what the Act is helping us clarify.
All right, so our present model of law on delegation is, it's an old one. It goes back to a case called Spate and Gaunt in the 19th century, and it tries to draw a distinction between the powers of a trustee to do things that involve discretion and the powers of a trustee that are just ministerial or administrative in context and character, and it's very difficult to be able to determine whether a individual power fits into the area of something that can be delegated, and or fits into the area of something that can't be delegated, and clearly the orientation of the law is not to allow delegation. And that really reflects family law trusts in the 19th century, where you had a personal trustee who wasn't being compensated, that was making decisions for family members. One of the major reforms in the UK in 2000, in England and Wales rather, was to reverse this and to allow for delegation in all circumstances, except in important things like exercising fiduciary discretion to make distributions. And that's essentially what this uniform statute is suggesting. The thing that is different now than years and years ago is that one can delegate important decisions to professionals. Those professionals are regulated, they're licensed, they're insured. If that's the case, it would seem not delegating important decisions to them is itself imprudent. And that was the thinking behind the British statutory reform. And I think that's the thinking here, is that the trustee has to maintain overall control. They have fiduciary obligations. They're the ones that can distribute or change the very nature of the trust. But other than that, let them delegate to professionals. It seems to be the right thing to do, especially since those professionals can successfully be sued for negligence. So again, a major reform if it's accepted.
All right, a fun one to discuss is the changes to the majority rules provisions, and again, talking about that, I mean, we do see a lot of tension that exists when even when you have a majority rules scenario where you've got, say, 3 trustees and there's a majority rules clause in the trust, and you see in situations where one of the trustees is constantly squeezed out of even almost right down to the administrative role, but is kept out of the loop generally. And once you get a grouping of 3, one going sour, it's very hard to recover. You know, if you're acting for the one that's been squeezed out, you've got all these obligations and all of these fiduciary accounting things and all of the sorts of fiduciary duties hovering around you, and yet you really have been, practically speaking, frozen out of the process, and that's obviously an awkward spot. Or if you've got a majority of trustees that are just blindly proceeding ahead without consideration of one of the other trustees, you also created their own issues and tensions. So the Act is at least touching on this issue a little bit. David, what do you think about the change and what, in the context of what the problem
I
is?
had a case against Ian a few years ago involving a majority rules provision, and his clients were unjust and unfair, making unconscionable demands about photographs.
Only clients I have.
So this provision is good. I mean, it does recognize that majority rules provisions are common, and it reverses the rule that we have now, is that unless there's a provision in the trust settlement, the trustees have to act together. Left out of this is part of the problem involving fiduciary obligations, which is just not addressed, as to the extent that if the trustees are acting oppressively or irrationally or, you know, something badly, whether that minority trustee who's been taken out still has remedies in respect of the court. But it's a simple change. It just reverses the present law. It assumes, if you don't put in a provision, that the majority of trustees can act even as against a dissenting trustee. The dissenting trustee is exculpated from liability, so they're not going to be liable for the decision. It just reflects practice, but there's still a lot more work, I think, that needs to be done if this thing is going to work properly.
One of the provisions in the Uniform Act really doesn't change the existing law on pre-taking of compensation. And David and I were chatting before, he was mentioning, and it's so true, is that, you know, we can't forget that when we're putting together these trust documents, boilerplate's boilerplate, but you can draft around problems. And one easy drafting around problem is to expressly say that the trustees can pre-take. And the Act is really just reflecting the common practice. So what are you finding, David, in the pre-taking, the dispute area for the pre-taking?
No, I think you're absolutely right. I mean, there are disputes, and the difficulty is that trust settlements may be silent on the point. The law is somewhat uncertain. It's allowable sometimes, not allowable others. Certainly in the state's context, that's different from the normal trust context. But the new provisions allow for a pre-taking with notice, and which allows for the beneficiary to demand a passing of accounts or something else. It seems like a fine rule. This is something that I really suggest that people that are drafting trust settlements look closely at this issue when they're drafting their settlements. Look closely at their precedents and consider these draft rules and whether they work for you or whether they don't work for you, whether they're brought into force or not, and just draft around them accordingly.
As only a professor can do, David, you have some fair and good criticism on the provisions of the Act at points, and one of them is, of course, the exemption clauses. Why don't we talk a little bit about what existing rules are there for mistakes by trustees and what the Trust Uniform Act has maybe done or not done on that?
Okay, so I feel like I'm doing my Viva for my PhD. And here's another question you didn't expect. This draft Act talks about exemption clauses. Sometimes they're called exculpatory clauses. You have a clause in the settlement that says that the trustee is not going to be liable for simple negligence, and you may couple that these days with a power to purchase errors and omissions insurance, or even have mandate the acquisition of errors and omissions insurance. Anyways. How far can you go in exculpating a trustee from liability? Unfortunately, there's a distinction that some people fail to grasp and is not really addressed within the Uniform Statute as well as I think it could be. You can exculpate or exempt a trustee from liability for failing to meet the duty of care that's incumbent upon him or her. So if they're negligent, you can exculpate them. But if they breach their fiduciary duties, liability is strict. They're acting dishonestly or unconscionably. And so, unfortunately, the Act has retained breach of trust, referring in a way to both. Right now we allow for a defense based on a trustee acting honestly and reasonably, both of them honestly and reasonably. This provision would allow for exculpation clauses to be allowed generally, or for the court to forgive liability where the trustee has acted wrongly, but the clause allows them to be forgiven, but still allows the court to say that if they've acted really terribly, then they can't be forgiven. And this just speaks to an issue that unfortunately is still unresolved in law and lays unresolved in this statute. Can you exculpate a trustee for gross negligence? And I think the answer is no, because gross negligence is akin to intentional bad behavior, which is breach of the fiduciary duty, and you can't get around breaching fiduciary duties. You can get around simple negligence. So good clause, but there's a little bit more work that could be done to clarify the law. I would, at the same time, counsel those people that are drafting trust settlements, including exculpatory clauses, to consider the extent of that exculpation, of that exemption from liability, and how far you want it to go, even in a situation where the trustee is not being compensated and it's a family trust, because somebody might replace them under the same conditions. How's that?
Excellent. So one of the rules that we can't ignore, unlike the rule against perpetuities, is the rule of Saunders and Voce. And it's Donovan Waters just wrote a really interesting article. It was published in the States and Trusts Pensions Journal, I think. I just read it and I forget what it was published in. But anyway, on this question, of the role of Saunders and Voce and role of beneficiaries, and also touches on variations of trusts. But David, first of all, let's talk a little bit about what the rule of Saunders and Voce is, and certainly how we have to be mindful of it in a drafting standpoint. And second of all, what the Uniform Act has touched on in respect to the rule of Saunders and Voce, and then the implications on variations.
Okay, so the rule in Saunders and Voce, you remember from law school, is one that says where you have all of the beneficiaries of a trust that represent all of the interests, and they're all adults, they can wind up the trust. So they can call on the trustee to convey the property to them, and the trustee doesn't need the court's permission. The trustee can wind up the trust and give the property to them. So in essence, it allows the different classes of beneficiaries to bargain with each other, sell each other their shares, and then just wind up the trust. What the new statute proposes to do is go one beyond that. What Saunders and Voce doesn't allow is the beneficiaries to vary a trust. You can wind it up if you represent all of the interests, but you can't vary it. The new statute would allow for variation, and so that is a layer of complexity that we haven't looked at in the past. And one expects that trustees would automatically, on a variation, be allowed to step out because they didn't agree to necessarily hold on the terms that the beneficiaries are now changing the trust to. But it also goes, this provision, it collapses the Variation of Trusts Act, allows the court to consent in the same circumstances on behalf of a minor or an unpoor person or an unascertained person to do something we haven't seen before, which is really neat. According to the statute, the court is going to be able to consent not just for a minor or an unborn person, but for an adult beneficiary that disagrees. So we've got a traditional problem of how do you vary a trust if there's an adult beneficiary out there that you can't find. The Variation of Trust Act doesn't allow the court to permit a variation or to wind up the trust because there's an adult out there that is ascertainable. This provision in part cures that, but it goes one step further and it says if you have a beneficiary that seems to be withholding their consent unreasonably, the court is now going to be allowed to consent to the variation over the objection of that person. And I think that will be a source of work for litigators. I'm not sure why it's gone quite so far, but it has.
It seems to me a charter challenge is in that one, but it's a very good illustration point, though. We're currently in a regime of it happens with passive accounts, it happens with variations, and that is that you just need one person to be a cog in the wheel, a problem, and the whole system falls apart. And sometimes a beneficiary will act vindictively or without paying proper attention to the suggestion of a variation. And it perpetuates the trust maybe unnecessarily. So it's an interesting step that the legislation is sort of pushing us to, but it's recognizing the current problem. And when we get into these situations where someone wants to vary a trust or retain us to vary the trust, we have to be very careful that we acknowledge that there's a 100% vote we need going in, and obviously if there's minor children involved, we need the children's lawyer involved. And in that scenario, of course, the children's lawyer, that contingent interest, depending on the contingency of it, are we talking about great-grandchildren, or are we talking about, the grandchildren are adults, but there's still a contingency of the great-grandchildren available. The Children's Lawyer's Office will benchmark what they say is their percentage of the trust that they'll want allocated instantly on the variation and the wind-up to go into court. So that's a negotiation you have with the Children's Lawyer's Office to allocate that portion of it, and then you get the rest of the adult beneficiaries all to vote yes. But obviously the whole thing falls apart if an adult beneficiary right now just says no, and they don't even have to say why. Because you're always dealing with the minor interests with intelligent, sensible negotiations with the Children's Lawyer's Office, so that issue gets to be negotiated out, as opposed to you really have no negotiation left with a more or less rogue beneficiary who just says no for the sake of saying no because they hate their sister. All right. We're just winding up now to the 9:30 point, so we're going to pass this back over to Susanna to close up, and we're available for questions on the microphone, and I'll leave over to you, Susanna.
Thank you, Ian. We had a couple extra questions that we just never got through today, so I think we'll, just in the interests of keeping up with our time, we'll pass on those. So sorry you weren't able to click for the last little bit. Our next breakfast seminar will be on June 12th, 2014, and we hope that you're able to join us. We thank very much Jonathan Cappy, Ian Hull, and David for joining us today. And we'd like to open it up to questions now to anyone who'd like to continue to stay and put some questions to this wonderful panel.
It's all on the exam.
Okay, I'm just going to check if we've got any call-in questions. Otherwise, it
Except for
looks
the
like
perpetuities.
we're good to wrap everything up. Thank you very much, and thanks again to our speakers.
Karen,